Senator King, you're recognized to suspend the regular order of business and the printing rule on committee substitute for House Bill 15.
Thank you, Mr. President. Members, I move to suspend the printing rule and the regular order of business to take up and consider House Bill 15. I guess I should say this is a little bit deja vu again and again. Members, this will be if we pass this out today, if it be your choice, this will be the fourth time in 2025 that we have passed this very same bill off the Senate floor. It stemmed from a 2023 sunset provision for T-Cole, which asked for a committee to be established to develop a model policy for all law enforcement agencies to use with regard to peace officers' HR files. The model policy that came back is one that is already used by many cities, I believe over 70 in the state of Texas. The bill will divide each officer's HR files into two separate files. One is called a personnel file, and the other is called a department file. The personnel file will contain substantiated misconduct complaints. These are complaints against an officer that resulted in disciplinary action. It will contain all commendations, congratulations, or an award bestowed on the officer, and all periodic evaluations of the officer by a supervisor. This personnel file is open to the public on an open records request. The other file is not available to the public. It is called the department file. It contains all coaching documents for where an officer has been coached, possibly by their immediate supervisor. It includes all personal information on the officer and their family. There have been situations where very personal matters have been released. It'll also include all their background hiring information, their credit reports and things like that were used in their background investigation. And of consequence, it will also contain all unsubstantiated misconduct complaints against an officer. These are complaints, which may be many, against the best officers. It will be complaints that did not result in disciplinary action because they were unsubstantiated. It's, again, there are a large number of cities such as Houston, Fort Worth, Arlington, Wichita Falls, Amarillo, Lubbock, Corpus Christi, McAllen, and many others, Austin as well, which are civil service cities, and they already use this exact policy. So basically, we're taking a policy that is already in state law, to use a personnel and departmental file, that is already used by many law enforcement agencies across the state, and we are adopting it at the recommendation of T-Cole's Model Policy Committee. We are adopting it statewide for all law enforcement agencies. And with that, I'd be happy to answer any questions. Oh, if I might, Mr. President, one thing I want to mention, this, of course, is the House bill. The House bill did add 2 amendments that have not been contained in any of the previous Senate bills that have gone over to the House. We have removed those 2 House amendments and would ask to send them back, the same bill that the House has previously passed out 3 times. I'm sorry, the Senate has previously passed out 3 times.
Senator Zaffrini, for what purpose?
To ask a question of the author, Mr. President.
Certainly.
Thank you, Mr. President. Senator King, in discussions of previous versions of this bill, you clarified that it does not affect current or future meet and confer agreements. That's still the case with this House bill, is that correct?
Yes, Section 143 of the Local Government Code sets up the meet and confer agreements for civil service cities. Austin, for example, is one of those. And it specifically states that it supersedes any other provision of Texas law. So this statute will not in any way supersede any meet and confer agreement that exists today or that a law enforcement agency and their municipality may enter into in the future.
Thank you so much. Mr. President, I ask unanimous consent that this exchange be reduced to writing and printed in the journal.
Is there objection? Hearing none. Motion adopted.
Thank you.
Senator Gutierrez, what purpose?
Thank you, Mr. President. Just to ask a few questions of the author.
Do you yield?
Certainly.
Oh, the sponsor, sorry. Thank you, Senator King. You mentioned a couple of amendments that were placed onto the House bill. One of them was the Don McLaughlin amendment. Are you familiar with that amendment?
Yes, I am.
What did that amendment do?
Well, to be honest, it's kind of hard to follow, so I can't tell you exactly what it does in actual practice.
So you don't know what the amendment did?
Well, I know what it says. I'm not exactly sure what it does. It wasn't very well worded. It had a lot of contradiction. That's one of the reasons we removed it.
Okay, well, I had a similar amendment that we placed on the original Senate bill, and it was amendment, I submit to you that mine was well worded. And I don't have that amendment in front of me. I don't intend to pose it again or pose Representative McLaughlin's amendment, but I think he likes to refer to it as the Uvalde amendment, which would allow parents and relatives of these types of offenses, victims of these types of violent offenses, victims of these kinds of negligent offenses by police officers to be able to view the reports in those incidences, the body cameras, the testimony between officers and the like. That's what his amendment intended. That's what he said on the House floor. And you have stripped out that amendment?
Yes, and that's really not what it does. This will not change anything that has occurred with regard to any type of files or documents involved in what the tragedy in Uvalde.
Well, Senator King.
If I may.
Yes.
What his amendment did, and again, it's very confusing in its wording, and I'm not criticizing him for that, it's just the way it is. It's very hard to follow, but it also has the same effect on this bill as if you had if the amendment had said strike everything below the enactment clause. It completely terminates this bill, strikes it for all effect.
It allows transparency for victims in those types of offenses, incidences.
What it would do is allow for information on unsubstantiated complaints made against an officer anywhere in the state of Texas to be made public to the media upon request, to be made public to any special interest groups, progressive groups upon request. It would potentially lead to doxing, and there have just been situation after situation where you take a very good officer who has false complaints made, maybe by someone they arrested trying to get out of that arrest, maybe just because they are continually out there doing a lot of hard work, they just generate more complaints, but they are found to be unfounded, unsubstantiated, and yet all of a sudden they end up in the press, in a media report, on a blog, in a Facebook post, and it becomes very embarrassing for that officer and for their family and can sometimes hurt their career. So what it would do, what his amendment would do, is allow that type of information to be made available. And I know we've talked about this every time this bill has been up, but I'm just here to tell you, unless you start protecting your police officers, your good officers, you're not going to have anybody that wants to be an officer in the state of Texas. And that's what this bill is trying to do in a very reasonable way, as well thought out through model policy. And again, this passed out of this body 3 times.
Well, you and I have talked about this the other day. There are good police officers and there are bad police officers. You would agree with that statement?
I would say the vast, vast, vast majority of officers in the state of Texas are good officers.
And some officers give a feces sandwich to a homeless man and say, eat this.
And you know about that because he was disciplined for that, and therefore that information was released, which would happen under this bill.
It was not allowed, and we've discussed this before. Now, what I'm trying to get at is if those families in Uvalde file complaints against the 96 DPS troopers that were on the scene and did nothing, that day for an hour and 17 minutes and let those kids die, and talked about how these things happen all the time in Texas, and talked about how they were afraid of the AR-15, and had talked about how they don't want to die today, and actually told the team that was about to breach, the federal team that went in there and finally went in there and killed that person, said, team that's about to breach, stand down. That was a high-level officer with the Department of Public Safety. God knows how long he might wanted him to stay. And the Texas Ranger that failed there too. If they filed complaints against all of these people under this piece of legislation, we'll never be able to see any of the documents, the camera footage, anything that is pertinent to that failure.
All of that information is and will continue to be available to prosecutors as well as to defense attorneys. Everything under the Sandra Bland Act will continue to be available. Everything under Michael Morton. All this is going to do is to say that if complaints have not been substantiated, if they are found to be unfounded, then those are not going to be made available to the public. Anything for which an officer is disciplined, even a simple written reprimand, a letter of reprimand in their file, that will be made public. And again, Senator, everything that happened in Uvalde was terrible, but this bill is not going to change anything that happened in Uvalde or anything with regard to the evidence and documents and investigations regarding that horrible incident.
Well, let's be clear. Those families, nor their lawyers, nor anybody, nor the media have been able to see any of those documents that you claim that would be able to see under the Sandra Bland Act and whatever else. None of those things have been exposed. None of those things have seen the light of day because the Department of Public Safety doesn't. Please don't talk over me. Please don't talk over me. Please don't talk over me. I've been very courteous to you. Please don't talk over me. None of those documents have been exposed in any way. None of those failures have been seen in any way. The entire failure of the Department of Public Safety and Steve McCraw and everyone else by the Department of Public Safety has not been seen by anyone other than people in this room. And that's by the way, it's very few people. I've seen all of it. Senator Nichols has seen all of it, and a few others have seen all of it, but very few people have seen the incredible failure, negligence, and malfeasance, and possible criminal liability of 96 officers of the Department of Public Safety.
But that occurred without this bill being in place, without this legislation. Again, this would not change anything that occurred in Uvalde. Had this bill been in place, the same thing would have occurred. My point, no, let me finish, please. And I apologize for interrupting you a moment ago. If there is litigation against an officer, that this type of information would be available through discovery. If there are criminal charges being pursued against an officer, the prosecutor has access to this information. The defense attorney also for the officer would have access to this information. If it somehow relates to a criminal complaint against a criminal defendant, they would have access to this information. This is only going to really affect the Open Records Act, and it's only going to prohibit unsubstantiated, unfounded complaints against an officer and their personal and private information from being released in an open records request by any random person. But if there is anything in a law enforcement investigation going on, if there is anything in a hiring investigation going on for an officer in the future, if there is anything going on in a prosecution, in a lawsuit, a civil lawsuit, this does not stop that information. It will still be made available to all the relevant parties. This is really dealing with open records requests by media, by third-party groups, and by individuals, and it's only going to stop personal information and unsubstantiated, unfounded complaints against an officer. That's the only thing it's going to shield, and that's the only people it will shield it from. It wouldn't affect anything that's happening in Uvalde. In fact, as you know, the district attorney in Uvalde who leads those prosecutions does not want that type of information released, and I presume they're holding it under an investigative status.
Those two people that have been charged in that case, you're suggesting that that information is available to their defense counsel. The fact is, there is also a civil lawsuit by those families against the Department of Public Safety, and they have not been allowed to see that information as yet. None of it. That's just simply a response to your question. My last question is this. The McLaughlin Amendment, there was a motion to table. That motion to table was set aside. 107 Democrats and Republicans voted to maintain that amendment on that bill, and you stripped it out just earlier in conference, correct? In your committee?
Yes.
All right, that's all I need to know. Thank you, Mr. President.
Thank you, Senator. Senator Hinojosa, what purpose?
Well, Senator King, yield for questions.
Do you yield?
Certainly.
Thank you, Mr. President. And we have debated this bill numerous times here on the Senate floor and in the Criminal Justice Committee. So I don't plan to re-ask those questions. But just a couple of questions, and that's just more for clarification. When a police officer moves from one police department to another, both files will be available to the new potential employer of the police officer?
Not only available, but current state law, and I think it was Senator Huffman's bill, if I remember, current state law requires that the agency that's considering the applicant, it requires them to request and look at that police file from the previous employment agencies, and all of the information, the department file and the personnel file, everything they've got on the officer has to be made available to that inquiring agency. Also, TCO, if there's an investigation going on, TCO will have access to those files as well.
And one more question. Right now, a police department, a city, can adopt this policy under House Bill 15 without having House Bill 15, the law.
That is correct, they can. And any civil service city in the state of Texas, any 143 local government code civil service city already is under it.
So why do we need this bill?
Good question. I think one of the problems has been and it's really just the subject of even some of the questions we just went through, there's just no consistency in file management among law enforcement agencies. And so when people are trying to get information on an open records request that they're entitled to or need, there's a lot of confusion among the agencies about what they should or can legally release. And this just takes and sets one policy statewide so everybody knows what the rules are for managing those HR files on every officer in the state of Texas.
So if House Bill 15 were not to pass, the local police departments or cities could still adopt this policy.
They certainly could, but they haven't. And the policies that's in the Civil Service Code has been there for some time. And some agencies operate under something like that or similar to. But again, there's just a lot of confusion. As you know, there's something like 1,700 law enforcement agencies in the state of Texas. I think something like 70% of them have 10 or less officers. And so what we're trying to do is put a consistent policy to make sure that every department.
HB number 15 by Hefner, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Chair recognizes Mr. Hefner.
Thank you, Mr. Speaker. Members, right now there's no consistency among law enforcement agencies regarding what files are made public and what files are not made public. Civil service cities, those that have adopted Chapter 143 of the Local Government Code, currently maintain both a separate personnel file and a department file for every officer. Chapter 143 requires the following documents to be held in the personnel file: substantiated misconduct complaints, commendations, congratulations, and/or awards bestowed on the officer, and periodic evaluations of the officer by a supervisor. All other documents not required to be held in a peace officer's personnel file must be held in their department file. This includes unsubstantiated misconduct complaints against an officer. Those are complaints that did not result in disciplinary actions, which means those that do not rise to the level of disciplinary action, training memos, counseling, coaching documents, and background hiring information. In response to a recommendation by the Sunset Commission, TCO commissioners adopted a model personnel department file policy for all law enforcement agencies that substantively mirrors the requirement of Chapter 143 for civil service cities. HB 15 codifies this model policy to prevent any conflict with current law. I want to stress HB 15 only affects requests for disclosure under the Public Information Act. If someone is suing a law enforcement agency or officer, they will still have access to documents in the department file via discovery as required by law. This is true for a prosecuting attorney attempting to access files, suppress criminal charges against an officer, defense counsel, and other police agencies. Additionally, this bill will not affect disclosure requirements under the Michael Morton Act or the Senator Bland Act. Senator King accepted an amendment on the floor, and we incorporated the substitute here that clarifies for the purposes of accountability and transparency of those specific acts. Mr. Speaker.
Mr. Speaker,
Mr. Tinderholt, for what purpose?
the gentleman yield for question.
The gentleman yield for questions.
Yes.
So I've had
Gentleman
several
yields.
people reach out, and they're trying to get a lot of people to vote against this, and I know your intent. Is the intent of this bill to try to hide what police officers do on a daily basis, or is it to protect good acting police officers?
It's to protect the good actors. This is a model policy developed from the 2023 session, and there was a committee formed of sworn and non-sworn individuals, defense attorneys, district attorneys, and they went all over the state and put this work product together. This is model policy that's been used by DPS for 30 or 40 years, and 26,000 officers currently operate under the provisions of this bill.
And if someone's disciplined and there's an issue with that police officer, will people be able to find those issues under this law?
Yes, if there is disciplinary action taken, that is subject to open meetings.
Thank you very much.
Mr. Speaker,
Mr. Moody, for what purpose?
ask the gentleman some questions.
Will the gentleman yield for questions?
Yes, I yield.
Gentleman yields.
Thank you, Mr. Hefner. I appreciate it. And I know we've had a number of conversations about this, and I certainly appreciate the time that you give me. I want to go through a few things, and it kind of pivots off of what Mr. Tinderholt said right now, because you're talking about substantiated claims versus unsubstantiated claims, right?
Right.
And so I think the conversation around your rank and file officers is that you have an unsubstantiated claim, and now somehow that's essentially being lodged against them in court. They were found to have acted properly, or whatever the case may be. And so now, like if you and I were accused of something and it was dismissed or went away, we wouldn't want someone then kind of coming after us with that information. That's kind of the crux of what we're going after, right?
Correct. On that specific issue of
Yeah.
unsubstantiated claims, yes.
And so this is a part I just want clarity on, because I think at least the concerns that I've had, and I've concerns of some folks that I've talked to, is there's the investigation into someone in how they dealt with a member of the public, and they go through that investigation, and that's unsubstantiated. The concern I have is the information that's not the information about the complaint and the investigation of the complaint. If it's unsubstantiated, I agree. Then we can set that aside. I'm trying to look at the underlying facts of the interaction with the public. So things like body-worn cameras, the dash cam videos, things that, the recording devices that officers routinely use now for both their protection and the public's protection. Mm-hmm. Those are not things that are going to go in the department file, are there? Or is that your intent for the underlying incident
No.
videos to go into the department file?
No, absolutely not. The body-worn footage and dash cam footage are in the personnel file. They are governed by their own specific code, and so they would not fall into the department file.
Is there anything that prohibits an agency from, because you're telling me what your intent is, but we all have a lot of intent when we write these, and then something goes on out there in the field. Is there anything here that prohibits the underlying incident that was investigated? I'm not talking about the investigation into the officer, because we've decided that we want to leave, that's outside the public's eye. But like the incident itself with the public, those videos, those 911 calls, those dash cam videos, is there anything that prohibits an agency from directing those into a file that is now not subject to public information?
No, the body-worn camera footage that is or could be used as evidence in a criminal prosecution would still be disclosable under the Public Information Act, and that's pursuant to the Code of Criminal Procedure, Article 2B-0112.
Okay.
That is what polices or governs how that camera footage is stored and that it is disclosable to the public.
And this is some of the clarity that I want to have with you. So we think about reports that come along with police interactions. So incident reports, the traffic stop reports, they have to file use of force reports, et cetera. Those are not permitted to be placed in this department file either, right?
Correct, that's my understanding. And keep in mind, what we're doing is we're taking the portion of Chapter 143, which, by the way, the original 143 was adopted in 1943. This is the gold standard of how these records are kept and stored that's been on the books for years. Now, obviously, it's probably been updated through the years, but it's been used by DPS for 30 or 40 years, and it's been used by these 26,000 officers across the state.
And so that's what I want to be clear about, because the thing that I don't want to be conflated here is there's the investigation into the officer for whatever the conduct is that they were accused of, and that's either substantiated or not. What I don't want to lose when something's unsubstantiated are the core records, the incident report, the traffic report, use of force report, the 911, the body cam video, the dash cam video, the recording on the lapel pit, all that stuff. All that stuff is still public record, and you're not permitted, like this bill does not permit these things to be placed in the department file, which has a bar on public information.
No, you're correct.
Okay. And a question on if and I see the sheriff standing next to you, so it reminds me, he was a peace officer. He's also an elected official. He was a license holder, peace officer, also elected. And so, and then you have department heads, right? So you have sheriffs, you have constables, you have department heads, the police chiefs, right? Those are people at the top of the agency. I know that, do you think we should have a different standard here for elected officials or department heads versus our rank and file officers?
I personally do not. I think when they take their oath of office, their oath to protect and serve, that the same rules should apply to them.
What if someone is they're a license holder under the statute, and they hold elected office otherwise? So county commissioner, city council, whatever the case may be, are they going to be able to avail themselves of these protections?
If they're acting in the duties, I'm being told a commissioner, like a county commissioner, would not, but an acting sworn officer would be under these protections.
Okay, they can keep their license, right? Even if they're elected.
Yeah, I know some
one of
people
these
that
other
have kept their
positions?
license, but I don't know that they're a practicing officer, like they're not active.
Do you think there's a difference in the level of public scrutiny that we should have over someone who is an elected official license holder but is not in the law enforcement business anymore?
I think if they were, when acting in the duty of a peace officer, they should be held to the same standard. I don't really understand the benefit of just putting an elected title beside their name would put them in a different box. I don't know how that would be applied. So the same standard would apply to all peace officers.
Whether they hold another office of public trust or not.
That's correct.
Okay, and you think that's
I think the level of scrutiny and the level of oversight and reporting and training and the things that we put on our officers all the time is adequate to hold them accountable.
No, and I know.
I don't know that increasing the requirements or the just because they're elected, even though they may not be active, I don't really understand the purpose that would serve. But this bill would not do that.
It would still offer them those same protections.
I guess if they were acting in the duties of a peace officer, but if they're just out there being a county commissioner, then no, I don't believe it would apply to their commissioner duties.
But I mean,
is that what you're asking? Like,
what I'm trying to get at is, I mean, does the public in that circumstance, when someone has decided to take on a position of public trust, should they not have a higher bar of scrutiny? Because I think what you're doing here is you're looking at your rank and file officers that, and I'll just accept what you're saying, and I as a prosecutor, I dealt with these when you had officers that had issues and the defense attorneys would go after them on the stand based on whatever we had to disclose. And so I get the concern, but when someone steps into or attempts to step into position of public trust, I would think that the scrutiny level will be higher, but I don't think there's nothing in here that would lift the veil for someone who's now stepping into a different position of public trust.
Well, when you talk about a position of public trust, to me, that the position of public trust and the burden that's put on a law enforcement officer in many ways is higher than elected official, because they're out there enforcing the laws, sometimes by force if somebody doesn't comply. And so I think we're getting this kind of backwards here. We already have such a high bar on our peace officers. I don't know how we would make sense of an even higher bar because they're elected, because they've already got a higher bar than electeds already. So, sheriffs, elected people that are certified peace officers have the same standards as other officers.
Well,
And
what I'm saying is the level of scrutiny, because the rationale behind this is to protect our rank and file officers from, unnecessary relitigation of things that have been unsubstantiated. But when someone avails themselves of seeking a position of public trust, you would agree with me that the public deserves to know more in that situation.
More of what?
Well, more information. I mean, they're seeking now they get to be provided with these levels of secrecy on these types of claims that are unsubstantiated, and there's no later change in that
I think
if they seek another position of public trust and they're still a license holder.
I
a license holder when
I believe the same standards should apply. I don't believe we should pick and choose different levels of scrutiny.
All right. I appreciate your time. Thank you, sir.
Yes, sir.
The following amendment, the clerk will read the amendment.
Is that Moody's?
Amendment by Moody.
Chair recognizes Mr. Moody to explain the amendment.
Thank you. Thank you, Mr. Speaker. Members, I know it's been a long day. I also know this is an amendment that I spoke about at great length the other day when we saw this as a Senate bill, and it does the same thing. It preserves the closure of the dead suspects loophole that was passed by this body last session in House Bill 30, and I do believe now it is acceptable to the author. So I move adoption.
Mr. Moody sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Hefner voting aye. Show Mr. Louderback voting aye. Have all voted? There being 125 ayes, 0 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by McLaughlin.
Chair recognizes Mr. McLaughlin to explain the amendment.
Thank you, Mr. Speaker. Members, as written, House Bill 15 would close off access to critical records after tragedies like the shooting at Robb Elementary. My amendment makes sure that complainants, officers, and most importantly, the families of victims will still have access to these records once investigations are complete. At the same time, it includes strict safeguards to prevent duplication or misuse. This amendment is for my hometown of Uvalde and for the Robb families who are still waiting for answers. 3.5 years, and they still don't have answers. My amendment does not change this bill. What it says, a person permitted to view letter, memorandum, or document under subsection F1 may not duplicate, record, capture, or otherwise memorialize the letter, memorandum, or document. A permitted viewing of a letter, memorandum, or document under subsection F1 is not considered to be a release of public information for purpose of Chapter 552 Government Code. And I can tell you, as the mayor of Uvalde, there were 4 investigations done on that shooting. 3 of them you can take and throw in the trash can. The only honest and true facts that you saw was the investigation that was done by this House in the 87th legislature, led by the Speaker and Mr. Moody. It's been the most truthful one that's been written to this day. And I can argue with anybody that wants to say it's not, because I was there that day, and I have to live with that day the rest of my life. I can't change it, can't do that. But these families have the right to know what happened that day. This amendment still protects the officers and their information. It just gives these families or complainants the ability to view those records themselves. Not copy them, not publish them, not print them, just to view the records and find out what went on that day. So, and with that, I've got a letter that the Robb family asked me to read, Lives Robbed. And I told them I would read it. I think they're owed that much and more. In wake of the tragedies like the one we experienced in Uvalde, transparency is not optional. It is essential. Senate Bill 15 threatens to block families and the public from accessing vital information about police conduct and accountability. Without that access, there is no way to ensure law enforcement upholds the highest standards of professionalism and integrity. Senate Bill 15 would hide police actions from scrutiny, making it harder to uncover misconduct, address systematic failures, and demand accountability when officers fall short. Secrecy does not build trust, it destroys it. Lives Robbed calls on the legislature to reject SB 15. Texas cannot afford laws that protect institutions over people. We must choose transparency, accountability, and reform to protect communities and to honor those we have lost by working to prevent future violence. And that was written by Kimberly Mata Rubio, Lexi's mom and president of Lives Robbed, representing the families. With that, I move adoption.
Mr. Speaker,
Mr. Little, for what purpose?
does Representative McLaughlin yield for a few questions?
Will the gentleman yield for questions?
Yes.
The gentleman yields.
Representative McLaughlin, thank you for offering this amendment. I know Chairman Hefner has worked extremely hard on this bill and has brought it several times and in several iterations. Obviously, I don't know whether he intends to accept this amendment or not, but it seems to me that the tension that has arisen right on the right and on the left in this chamber is over who should have what information about law enforcement. And on one extreme, we have people saying we must have transparency, we must have sunlight to be able to look at what occurs in law enforcement. On the other extreme, we have people saying we must look out for law enforcement officials and protect their reputations when there are unsubstantiated allegations. it seems to me that the purpose of your amendment is to ensure that information is provided to families who are impacted by law enforcement in some negative way without requiring the dissemination of that information out to the general public. Is that what you were going for here?
Yes, most definitely.
And you'll have to excuse my ignorance over not knowing everything that the families in Uvalde have gone through, but it seems to me they've been trying to obtain information and have been unable to do so for some period of time. Is that right?
It's 3.5 years and still fighting right now for information.
What specific information is it that they want that they've been unable to obtain?
Well, the DA won't release it and keeps using an investigation. We've already had a criminal investigation. 2 officers were indicted out of 391 there that day. Two years later, they just want to know what the actions were, what the report says these officers did. Look, I was there that day. Were bad decisions made? Most definitely. Poor judgment used? Most definitely. Do I think what was done that day was criminal? I do not. I do not think what those officers did. I think poor judgment was used in that, but I do not think it was criminal. But these families that lost 19 kids and 2 teachers, they have a right to know what happened that day or what the actual report says. And like I said, there's been 4 reports written. 3 of them you could throw in the trash can. The most honest one has been the one that came out of this house.
I see. It seems to me that one of the painful reminders that those families have to have is that they're seeking information that some law enforcement agency is putting in a box where other people can't obtain it, whether it's under an investigative privilege or some other place. But it seems to me that one of the concerns raised in the bill is that the same type of information those families are seeking to obtain will simply go into a department file where it will once again be unobtainable. Is that your assessment?
Correct. Once they see it, it goes back into that document. It's not unless there's a lawsuit filed, that material will not be open to the public.
Well, I appreciate very much your thoughtful amendment, and I hope we'll have the opportunity to vote on it. Thank you.
Thank you.
Mr. Hefner in opposition.
Members, I've gotten to know Representative McLaughlin the last few months, and he's one of my favorite people in this chamber. He's a man of integrity, and he has a great heart for his people, and he's served on a Homeland Security and Public Safety Committee with me, and he was a great member and ally there. About the unfortunate events that happened in Uvalde, this bill would in no way hide any of those records. Those records have not been kept from the public eye by law enforcement officers. They have been sealed or withheld by the district attorney in Uvalde. This bill seeks to apply statewide model policy that already applies to 28,000 police officers across this state. This is policy that we directed T-Cole to develop, and they spent 2 years developing a statewide model policy so that we have uniformity and consistency across the state. So those events at Uvalde and other shooting incidents are not going to be withheld under the provisions of this bill. Again, those are not being held by the law enforcement agencies. It is the district attorney of Uvalde that is withholding that from the public. So with that, I respectfully move to table this
Mr.
amendment.
Moody, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions?
Yes.
He yields for questions.
Thank you, Mr. Hefner. And I think you heard in Mr. McLaughlin's layout of this amendment make reference to the House Investigatory Committee report in the wake of the tragedy at Robb Elementary. You heard that part of his remarks.
Yes, sir.
Do you know why our report was the most accurate report to date and is held up against scrutiny to this very day?
No, sir.
Because we had all the information, terabytes of it, stuff that I never wanted to see, never wanted to read, but it was our job to do that for the families. And the reason we did our job is because we had complete access to everything. That's why.
Members, again, these records are not being held by law enforcement officers. They're being withheld by the district attorney in Uvalde.
Speaker,
Speaker Reverend Hoggins, for what purpose?
will the gentleman yield for a question?
Gentlemen, yield for questions.
Yes.
Representative Hefner, I'm trying to understand. We're saying we want transparency, and you're against a amendment that will add transparency?
I'm against what I'm trying to do here. What we're trying to accomplish is to protect our officers, people who wake up every morning, and they put on a bulletproof vest to go to work. And unsubstantiated claims, hiring background information that has to do with their private family members should not be disclosed to the public. What happened in Uvalde is a horrible, tragic event. But this bill does not hide any of those records. It would not whatsoever. That is being withheld by the district attorney of Uvalde, not law enforcement officers. And so we're talking about viewing the personal information of peace officers who get up every day. Do you put on a bulletproof vest to go to work every day?
Representative Hefner, please don't come at me like that.
Do you?
Matter of fact, I got family members that are police officers.
I do too.
So I do understand the gravity, sir.
And I don't want to see these slimy lawyers out here all over this state use this file to impugn men and women that put on a bulletproof vest to go to work every day to keep the rest of us safe.
Mr. Speaker, can I ask the gentleman questions, or he wants to preach about his side?
Members, please take your conversations outside the rails.
So, Representative Hefner, are you willing to answer questions, or? So
Ask away.
So my question is related to, I appreciate police officers too, and then you say TCLO worked 2 years to craft something. So the people who have the information have said, let's seal the records, and that's okay with you?
This is already, Ms. Gervin Hawkins, this policy already applies to 28,000 law enforcement officers across this state. We're not doing anything new. This has already been done for decades by 26,000 officers across this state. We're trying to balance transparency and due process and protecting the information.
Thank you, Representative Hefner. Thank you.
So be it. No, I'm not. Members, I respectfully move to table.
Okay. Mr. McLaughlin sends up an amendment. Mr. Hefner has moved to table. This is a division vote. Clerk, ring the bell. Record vote has been requested. Record vote is granted. The clerk will ring the bell. Have all members voted? Have all members voted? 19 ayes and 107 nays. The motion to table fails. The amendment is acceptable to the author. Is there objection? Chair hears none. The amendment is adopted. Is Ms. Jones of Harris on the floor of the House? Anyone wish to speak on, for, or against House Bill 15? Mr. Hefner to close.
Move passage.
Question occurs on passage of House Bill 15 engrossment. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 87 ayes, 41 nays. House Bill 15 passes to engrossment.
Keeps the right records, puts them in a file, and everyone knows what they can and cannot access and through what vehicles they can and cannot access those files.
Thank you, Senator King, for answering my questions.
Thank you.
Secretary will call the roll on suspension. And the
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook, Creighton.
18 ayes, 9 nays. The rules are suspended. Chair lays out on second reading committee substitute for House Bill 15. Secretary, read the caption.
House Bill 15, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
You're recognized on passage to third reading.
So move.
Secretary will call the roll. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco.
17 ayes and 10 nays. The bill passed the third reading. If you want to see if you can find 4, it may save everyone a day.
I will try that. Thank you.
Senator King, you're recognized for a motion to suspend the constitutional 3-day rule on committee substitute for House Bill 15. We're coming back to you.
So move.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
22 ayes and 5 nays. The rule is suspended. Chair lays out on third reading and final passage. Committee substitute for House Bill 15. Secretary, read the caption.
Committee substitute House Bill 15, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
You're recognized on final. Sorry.
Move final passage, 4th time.
Yes. Yes. You're recognized for what purpose?
To speak against the bill.
You're recognized.
Thank you so much, Mr. President. So there's been a few things said about this bill, and I know we've talked about it about 100 times. One of the things that keeps coming up is that we're universalizing existing law, but that is just not the case. There's really, really big differences between Chapter 143, what's going on in existing law, and what will pass under this bill. It's also been said multiple times this is only about unsubstantiated claims, but that's also not true because it says any and all documents over and over again. And I also know that we've had some conversations about how certain police officers who do too little don't get in trouble. If you do too much, you do. What we're looking for in law enforcement, like nursing, is just right. It's not too much or too little. It's just right, and it's integrity, and it's a commitment to the public and its transparency. And I just want to note for the SAPD officer who fed the homeless person a disgusting sandwich and is now employed again by another agency throughout the state, their city manager said this individual clearly had no business wearing an SAPD uniform, and it should have never been this hard to fire him. I'm pleased that this is behind us, but the contract provision that gave him more chances than he deserves remains an obstacle to the chief's ability to discipline officers who fail to live up to SAPD standards. So it's interesting that we're looking for more secrecy and being asked to enshrine secrecy in statute today, to create by law a system where those who wield the ultimate power of the state can shield their failures from scrutiny and their misconduct from accountability. We've talked a lot about Uvalde, where a lot of people were killed, and for 77 minutes, armed agents of the state sworn to protect failed catastrophically. And then we all know what followed was a masterclass in institutional self-protection. Agencies stonewalled, records hidden, information denied. It took a legislative committee with special access privileges to uncover the truth, and years of litigation to force transparency, and even now the families are still fighting. And I know that we've talked about how this bill maybe doesn't impact that, but I believe the families. And I know that their reading of this is informed by what they've experienced, and if they have concerns, I've got concerns. Under this bill, those documents could be sealed forever. This is the law enforcement establishment's latest demand for special treatment, And I say that as a nurse who does not receive special treatment. We are held to an extremely high standard because we should be, and we can be. And law enforcement is the same way. But we are about to enact more statutory secrecy to hide failures from public view. And we know that the ability of the press to get a hold of some of this information has led to life-saving changes in my own city and my own county. And with that knowledge, I'm just shocked that we're coming back to this bill again. When did we decide that police officers with badges deserve lower standards and less accountability than nurses and scrubs? When did we decide that public servants funded by our taxpayer dollars should operate in the shadows? The greed is breathtaking. The belief that power comes without responsibility, that authority requires no accountability, and that those who serve the public should be exempt from public oversight. Y'all, the families in Uvalde deserve better. Families who lose loved ones in custody every single day in this state deserve better. And the taxpayers who fund law enforcement deserve better. The public that trusts a system with extraordinary power deserves better. This bill tells them all your grief doesn't matter. Your questions don't matter, your right to know doesn't matter, and what matters is protecting the exact people who failed you, or maybe even in some cases harmed you, from ever being held accountable. So we have a choice. We can enshrine secrecy in statute and tell the world that in Texas, badges and guns come with blank checks, or we can reject this institutional power grab and remind everybody in this state, and quite frankly, remind the deep state, there is no one above the law. So I hope y'all will consider voting no. Thank you.
Senator King, you're recognized on final passage.
Move final passage.
Secretary will call the roll.
Alvarado, Betancourt, Bordeaux Blanco.
18 ayes and 9 nays. The bill is finally passed for the 4th time. Thank you.
Thank you, Mr. President and members. Thank you for your patience.